This podcast represents a brief history of the law relating to the issues raised. This should not be relied on as a substitute for professional advice. Specific legal advice should always be sought in relation to any particular circumstances, and no liability will be accepted for any losses incurred as a result of reliance on this podcast by those relying solely on this podcast. Welcome now to Hicksons Health Hour, the podcast series that explores a variety of current legal health topics. Throughout each episode, hear from different members of our health team with expertise in the area.
Hi, my name is Emma Ellis and I'm a partner in the health team. Today we'll be speaking about surrogacy laws in New South Wales. The New South Wales Government has initiated a review to consider whether legislative amendments are required to sufficiently protect the rights of children and meet the needs of various family structures who conceive using fertilisation or surrogacy arrangements. The purpose of the review is to canvass a broad range of community views to determine whether existing legislation is up to date and fit for purpose. The review will consider whether the current legal framework is up to date with the current social needs, including ensuring the best interests of the child are paramount in every case, that the law offers sufficient protections for birth mothers, that there is equal status of children regardless of family structure, and that parentage is appropriately established. And finally, does the legislation meet the needs of families who conceive using fertilisation procedures and families created through surrogacy arrangements? Joining me today to discuss Australian surrogacy laws is Tain Moxham, a special counsel in our health team here at Hicksons. Welcome, Tain.
Thanks for having me, Emma.
What is surrogacy?
Surrogacy is an arrangement where a woman, known as the birth mother, is or will try to become pregnant, agrees that following the birth of a child, another person or couple, known as the intended parents, will become the legal parents of the child. After the child is born, the legal rights and responsibilities of the child are transferred to the intended parents through the making of a parentage order by the Supreme Court. In New South Wales, surrogacy is regulated by the Surrogacy Act 2010.
So are there different types of surrogacy arrangements?
There are two main types of surrogacy arrangements, altruistic and commercial. In altruistic arrangements, the surrogate mother receives no payment or only reimbursement of reasonable expenses associated with the pregnancy. Commercial arrangements involve paying a fee to the surrogate for conceiving or carrying the child. Australia only allows altruistic surrogacy. In New South Wales, the maximum penalty for entering into a commercial surrogacy arrangement for an individual is $110,000 or 2 years imprisonment or both. However, there are no known cases in New South Wales where these penalties have been imposed. Yet commercial surrogacy is permitted in other countries, including some states of the United States, Ukraine and Mexico.
As you have mentioned, in New South Wales, surrogacy is regulated by the Surrogacy Act. What does the Act seek to achieve and how does it regulate surrogacy arrangements?
The main goal of surrogacy laws in Australia is to prevent the exploitation of vulnerable people, avoid turning reproduction into a commercial transaction, and, most importantly, to protect the best interests of the children involved. When it comes to the Surrogacy Act, its objectives are pretty clear. It aims to protect the rights of children born through surrogacy, provide clarity for anyone involved in these arrangements, and importantly, it bans commercial surrogacy. Now, under the Act, surrogacy arrangements aren't legally enforceable, except when it comes to paying or reimbursing the birth mother's expenses. Either the birth mother or the intended parents can change their minds at any time, before or after the birth, until a court officially makes a parentage order. So, for example, if the birth mother decides to keep the baby or even terminate the pregnancy, the intended parents can't take legal action against her. Similarly, If the intended parents decide not to proceed with the transfer of parentage, the birth mother can't take them to court either. The reason for this is that enforcing a surrogacy agreement would go against the principles that all parties involved must give their full and voluntary consent in transferring legal parentage from the surrogate to the intended parents.
So who can engage in a surrogacy arrangement in New South Wales?
In New South Wales, there are a few key requirements for a surrogacy arrangement to be valid. First, the agreement has to be made before conception, and of course, it can't be commercial. For the intended parents, they must be at least 25 years old and residents of New South Wales. There also needs to be a medical or social reason for pursuing surrogacy, like if the intended parents are unable to conceive or carry a child to term themselves. That being said, the court can sometimes waive this requirement in exceptional circumstances. As for the surrogate mother, she has to be at least 25 years old when she enters into the arrangement, though she doesn't have to be a resident of New South Wales or have had children before. If the court waives the age requirement for the surrogate, she has to have been over 18 at the time of the arrangement.
As you've touched on earlier, surrogacy is regulated by each state in Australia. Are there any major differences between each state?
Yes, there are a few important differences when it comes to surrogacy laws across the states. One major difference is how they handle international surrogacy arrangements, and also the eligibility of same-sex couples to participate. So, while all states ban commercial surrogacy within Australia, New South Wales, Queensland, and the ACT are the only ones that also specifically ban international commercial surrogacy. Meanwhile, Victoria, Western Australia, South Australia, Tasmania, and the Northern Territory do not expressly extend their commercial surrogacy offence laws to conduct engaged in overseas. In relation to same-sex couples, all states aside from Western Australia permit same-sex couples to engage in surrogacy arrangements. In Western Australia, singles are also not eligible.
So why is there a need for change in the current surrogacy laws in New South Wales?
Well, there are a few key reasons why they need to be changed. While the laws were created with good intentions to prevent exploitation and protect everyone involved, they end up making surrogacy more difficult to access and navigate. This can push people to look for surrogacy options in other countries, which comes with its own set of headaches like legal confusion and potential risk for the child. For example, the process of obtaining a parentage order is expensive, complicated, and time-consuming, causing significant stress and uncertainty for families, especially those returning from overseas with a newborn. We also need to think about families in the LGBTIQA+ community. Surrogacy has changed a lot since the laws were first put in place in 2010. What worked back then doesn't always match up with the needs of modern families today, making change necessary.
What kind of changes are being suggested for these laws?
Solicitors specialising in the family creation space have suggested several changes to simplify surrogacy laws. One idea is allowing paid advertising to make finding a surrogate easier. Another is removing the New South Wales rule that bans residents from participating in commercial surrogacy overseas. While this rule hasn't stopped people from going abroad, it adds stress and stigma for families. There are also questions around the need for separate pre- and post-pregnancy counselling sessions, suggesting that one counsellor could manage both for greater efficiency.
What kind of backlash do commentators think these changes may face?
Allowing paid advertising for surrogates could raise concerns about the commercial nature of surrogacy, making it feel more like a business transaction than a supportive arrangement. and raising ethical questions about potential exploitation. Lifting the rule banning New South Wales residents from participating in commercial surrogacy overseas might be criticised for encouraging people to seek options abroad, potentially leading to less regulatory oversight and increased risk for children. Streamlining counselling by using one counsellor instead of separate sessions could worry critics who feel it might reduce the depth of support and preparation for both the intended parents and surrogates.
What about the more complex changes? Are they likely to face similar backlash?
Yes, there are potential concerns there too. In New South Wales, surrogates can only get reimbursed for the out-of-pocket expenses they have incurred during the pregnancy. It has been suggested that surrogates should be compensated for their time and effort. This could include a set of monthly payments during the time they're trying to conceive and throughout the pregnancy, in addition to covering their expenses. Again, there is a fear that this could open the door to situations where surrogacy becomes more like a business transaction rather than an altruistic arrangement. Another important issue is children born overseas through surrogacy. These children can get caught in a legal grey area where their parentage isn't recognised under Australian law. A commentator's suggestion is that we should create a rule that automatically recognises the intended parents as the legal parents, without needing to go through a court order. This change would be a huge relief for families and might even encourage more people to choose surrogacy within Australia, rather than going overseas. Still, some fear this might lead to misuse without thorough checks, risking the welfare of the child and leaving parents suitably unverified.
It will be interesting to see whether these changes are implemented to address the challenges currently faced with current surrogacy laws in New South Wales. Perhaps we should look at other countries and how they deal with surrogacy, such as the US.
Yes, to understand how these changes will look if implemented, consideration of surrogacy laws in the US is a good starting point, especially as in recent years, the US has been the country in which most Australians have undertaken surrogacy. Similar to Australia, surrogacy laws are regulated on a state-by-state basis, rather than under a federal body of law. In most states, there aren't any clear surrogacy laws, while others allow both altruistic and commercial surrogacy. Then, you have a few states that go as far as criminalising all forms of surrogacy. One state that stands out is California. It's been known as a surrogacy-friendly state for a long time. California permits both altruistic and commercial surrogacy, and has a system in place that makes it very smooth. They use pre-birth orders and written surrogacy contracts made before conception, which allows the transfer of parentage to the intended parents before the child is even born. This means that both genetic and non-genetic parents can get a pre-birth parentage declaration as long as the agreement is valid. In California, recent court cases have ruled that if a child is born through assisted reproduction, both partners, regardless of marital status or sexual orientation, are automatically considered the legal parents. This flexibility, combined with the fact that commercial surrogacy is allowed, makes California a popular destination for Australians looking into international surrogacy. That said, it's not without its challenges. For intended parents living outside the US, there are still some hurdles to clear. For a child born through surrogacy to leave the US and join their intended parents, the child needs a US passport, court approval, and a birth certificate that lists the intended parents. But even with all that paperwork, it's often easier than navigating some of the tougher surrogacy laws back in Australia.
Surrogacy laws are definitely a point of interest and an area we should continue to watch in light of the proposed changes. Thanks for being here, Tain, and thank you to our listeners for joining us on Hicksons Health Hour. Stay tuned for our next episode where we continue exploring the intricate interplay between medicine, law, and society.